Everybody knows the outcome of the general election. 133 seats to Sivarasa National, 89 seats to Pakatan Rakyat. And it's also undisputed that we have 51+% of the popular vote. And Barisan is running the government with 47+% of the popular vote. It's something unprecedented in the history of this country. And I think unprecedented in probably any fair and equitable first-past-the-post system. Now, in a first-past-the-post system, it is quite common that the winner of the election can get below 50% of the votes, 40-odd% perhaps, and get a majority of the seats. That's quite normal in a first-past-the-post system. But it is quite unheard of when the losing party gets 51+% or the majority of the votes in the first-past-the-post system and loses. That's what's happened in Malaysia. So that's an indication of the distortion in the system. The extent of the malapportionment and the distortion, the fundamental distortion in the system. And that's going to be one of the challenges that we will face in the future, and the continuing struggle for reform that's ongoing. And it's also, I think it's important to say this before I go straight to the election petitions itself, that Pakatan Rakyat achieved that support, that popular support, with practically no access to the mainstream media. So, I mean, and many of you know the election processes in your countries, which are much better, a lot of which are much better than ours. The fact that the key leaders of Pakatan Rakyat, particularly Sivarasa, had no presence in national television, no presence in national radio, no presence in the daily press, apart from negative publicity, and yet we managed to get 51%. And so that raises the question, if it had been a fair process, fair access to the media, where would Pakatan Rakyat be? And I think we all know the answer to that. Now, we were challenged post-election after mobilizing popular response to the Black 505 rallies. We were challenged politically to say, go to court. There's a court process available to you for your grievances. Go to court and we'll fight it out in court. And that's what we did. We took that challenge. We announced that we would be filing election petitions, and Party Keadilan itself filed 21 petitions, 20 in parliamentary seats, and 1 in the state seat. Our colleagues in PAS filed about 18, 14 state seats, and the rest in parliament seats. DAP took up 2 petitions in parliament seats, all in about 40. The Barisan National also put up election petitions. Most of we thought were a joke, but anyway, I think they decided to try to match us in numbers, but they filed probably about a dozen election petitions, 3 in Terengganu, some in Kelantan, and in a few others all over the country. Now, what I think, I mean, this has even shocked us with the kind of response that happened in court. As of today, I'll just focus on the Keadilan petition, the 21 that I mentioned just now, 20 parliament seats and 1 state seat. All have been struck off except for 3. Struck off in court without a hearing on arguments of pure technical arguments. Basically arguments were put that the petitions were irregular for some technical reasons. And I'll give you examples later of the kind of technical reasons that were raised, and these reasons were used to strike off these petitions and prevent them being heard through the process provided in law is a full trial. In other words, witnesses will come to court and talk about abuses, as happened on the ground during the election campaign and on voting day. None of that was allowed to take place. So the 2 petitions was waiting for decisions, in Segamat and Tawa, we expect the same thing to happen. Only one petition actually went to trial, and that was in the state of Sabah. So as of today, we have only one Partikatlan petition for the seat of Kota Marudu going to a full trial, and within that same parliament, we have the state seat of Klias, 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 which is filed by the Barisan Nasional against our winning candidate, and that is also going for trial. I mean, that's reasonably fair. Both sides being allowed to trial. But that's about it. Somehow the judge in Sabah, for some reason, didn't get the instruction. I don't know how it happened, but obviously it went past her, him, and that trial is proceeding. So it's only the trial of Kota Marudu, the election petition of Kota Marudu, that we've been able to present our evidence of election abuses. How, for example, the Form 14, which is the tally sheet in each voting stream, which is very fundamental. It's the final outcome, the certified outcome of the votes. How in many instances there, the Form 14 was not given to our candidate's representative, which is mandatory under the law. So this is an example. And this has happened in other seats as well. But in all those other seats, our petitions were struck off, and these issues are not allowed to come to trial. The same has happened to the past petitions and the DAP petitions, and also happening to the Barisan petitions, except for the one I just mentioned. So, and let me give you an example of the kind of technicalities that are being used to strike off petitions. We accept that election petitions are a specialized area of law. There are different technicalities from the usual civil process, but in this series of election petitions, post-GE13 general election, we are seeing the technicalities being taken to heights of absurdity, farce. I'll cite you the Thapa petition, where I appeared in person. My presence was objected to by the other side on the basis that myself and other senior counsel's names were not in a form which was filed at the time the petition was filed. Again, we say that these things were wrong in principle for the court to agree to that argument. When a petition is filed 3 weeks from the time the results are gazetted. You have 3 weeks to prepare and file a petition. When you file a petition, you name one lawyer on which to serve documents, which is quite understandable. One lawyer. The rule says an advocate, and an advocate was named. But of course, anybody who goes to court then may appoint additional lawyers to argue his case. Counsel is appointed. And that right is fundamental, and that right is given until right up to the end of the process. But in this petition and other petitions, the argument was taken that the petitioner had to name all his lawyers at the time he filed his petition. In other words, if your name was not there at that point in time, you could not name any of the lawyers. But on the other side, the respondents could name lawyers right up to the end of the trial. So that obviously, that interpretation is obviously flawed. But that interpretation was applied, so myself and other lawyers had to step out, leaving the solicitor who filed the petition. This is how ridiculous it got. He had filed his papers properly, filing something called a notice penesahan peguam, appointment of lawyer. You know what the court said? Your form says peguam, it should have said peguam bela. Many of you who know Bahasa Malaysia will know there's not much difference between the word peguam and peguam bela. Therefore, your notice of appointment is void, and you cannot argue the case. So the lawyer said, well, I followed the circular from the federal court, which says notice penesahan peguam. Oh, that's only a guideline. This is the law. So he was told to step out of court and not represent his client, Mr. Vasantha Kumar, our candidate Thapa. So Mr. Vasantha Kumar then says, I'll argue it myself. The court says, no, you can't argue it yourself. Because you have appointed lawyers, your lawyers have now been disqualified, you cannot continue. And then he is told to step out of court. Now the petitioner, the person who brings the case to court, is told to step out of court. And the court then proceeds in his absence. And hears the objections of the other side and strikes off the petition in his absence. That was the third part of the comedy in Tapa. And now the final act. The court awarded a total of 190,000 ringgit of costs against him at the end of that petition. That was one example. Now, any practicing lawyer in Kuala Lumpur will tell you, of course, cases are sometimes knocked off in preliminary stages on technical points. You make the argument, you succeed. The normal costs awarded 5,000. Usually, at the high end would be 10,000. In this case, our candidate was punished with 190,000. So we have a range of costs from 60, 100, 120, 150, 190 being awarded in all these petitions. So they're being struck off on farcical technicalities and punishment. Punitive costs are also being awarded. So that's been the fate of every petition we filed, except, as I said earlier, for Kota Marudu, which is the only one allowed to go to trial in Klias. And so I come back to the political challenge that was put to us earlier by the Prime Minister said, take your issues to court, don't go to the streets. And we're being blocked from ventilating any of these issues. So, where do we go from here? Civil society through Bersih has organized what's called the Bersih Tribunal, the Bersih People's Tribunal, which will sit for 5 days starting on the 17th of September for that whole week. And an eminent panel has been assembled, led by Professor Yashka, a prominent academic from Kenya, 3 overseas luminaries together with 3 local intellectuals will be part of that. 6 of them will be, the panel will be hearing the evidence, and I think that will be perhaps one opportunity you might want to send observers to, where we will get at least to see first-hand from some of the witnesses evidence in terms of what happened during the elections. That'll probably be the only occasion, or rather the main, hopefully not the only one, but that will be one opportunity to get to know some of these evidence firsthand. And Selangor and Penang, the Pakatan state governments, have also announced the formation of a commission of inquiry, which at some point will also look into the electoral abuses which took place, but they are of course restricted in the scope. They'll only be able to look into events within the state of Penang and Selangor. But even then, even though those states were won by Pakatan with solid majorities, but nonetheless electoral abuses did take place, and when those commissions of inquiry take place, then they will form a platform where some of that evidence can be placed on public record.